The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to this special sitting of the United States Court of Appeals for the Fourth Circuit. My colleagues, Judge Niemeyer and Judge Berner, are very pleased to be with you this morning and very much appreciate the kind hospitality of the Elon University School of Law and Dean Kramer and the entire staff who have been so gracious and accommodating both last night at the dinner and this morning. We have 3 cases on for argument this morning, and we'll begin with 24-1828 Needham versus Merck. Mr. or Ms. Bronston.
Thank you. May it please the court, my name is Marjorie Bronster, and I'm representing the appellants in this matter. The Vaccine Act is central to this appeal, and while I intend to point out some of the grave errors committed by the district court on the timing, on the statute of limitations, on treating that time restraints as jurisdictional, and on equitable tolling and other procedural and legal issues, what I'd like to start with is the constitutional question. It is the fundamental issue that needs to be addressed. We contend that the Vaccine Act is unconstitutional. The act on its face and as applied violates the presentment clause of the Constitution, Article 1, Section 7, and given the non-severability provision in the act, the whole act fails.
Ms. Bronster, can I ask you about that? So if we disagree with you on the first issue relating the requirement to complete the process that the Vaccine Act provides for litigating these kinds of cases up through the vaccine court, then the Court of Federal Claims and the Federal Circuit, and I'm not suggesting that this is what we're going to do, but if we were to affirm the district court on that issue, would we reach the presentment clause issue?
Yes, I believe you must. And the reason for that is that to make that determination, you have to decide whether or not the Vaccine Act is constitutional, because by applying the act, you're impliedly deciding that it is constitutional. But if, as we submit,
the avoidance doctrine, we usually don't start with the constitutional claim against a statute and find it unconstitutional if there are other grounds for it by which to decide the case. And I must say, when was this act passed? What, 1986 or something? Like
yes.
that? So here we are, 40 years later. Nobody's raised this. You have a process that's not unlike the Controlled Substances Act in listing components on the list. I must say, you can present it and you can argue it, but you might have a more fruitful time on some other issues. But that's just my observation.
I understand, Your Honor. However, I believe that because of the fact that deciding this case on the timing issue alone presupposes that that timing issue set forth in the Vaccine Act is constitutional. And when you look at this act and you see the wording of the statute that says—
Not at all. Constitutionality is not jurisdictional. It's sure, it's important, but if you ordered to bring a claim under a particular cause of action, and there's a statute of limitations on it, we don't have to look at the nature of the cause of action or the constitutionality of statute under which it's brought. But you can make your constitutional argument. I didn't want to preempt that at all. I just wanted to give you some.
Well, I will
certainly think about.
Thank you. I will certainly try to keep some time to address the other issues. In 1986, the Vaccine Act was passed by Congress and approved by the President. And its aim was to address a crisis involving the DTP vaccine. Because it was not cost effective to make, it was causing a small but significant number of kids to be severely injured. And Congress at that time negotiated a balance that would grant certain immunity to manufacturers, but on the other hand, it would grant a quick and fair and easy way for injured children to get compensation without having to prove causation.
Counsel, why isn't the Vaccine Act like the Tariff Act in Field and Clark? It seems to me that it's pretty close to being on all fours.
Actually, we believe that the Vaccine Act is on all fours with the Line Item Veto Act.
Except that the Line Item Veto Act gave the president complete discretion what aspects of a bill to strike, what to leave. So it really was, in essence, a rewrite of what Congress passed. But here, there are certain conditions that have to precede the addition of a vaccine, including the addition right to the tax and also the CDC recommendation that they be added. So the secretary can't simply add a vaccine. There needs to be certain things that take place. And in fact, after those things take place, it's my understanding the secretary has to then add the vaccine. In essence, it's exactly the actor that needs to present under the presentment clause.
Well, the tax actually does not change the vaccine table. What it does is it sets the time at which it's a timing issue, not a change issue. And I think the most important reason—
It's a regulatory issue. Congress is now bringing within the umbrella of the funding for this Vaccine Act, the vaccine. And you would just separate the two entirely, I gather.
No, because I believe that the act itself, if you look at section 14, the one that gives not only the authority to the secretary, but also the mandate to the secretary, there is a tremendous amount of discretion. First, the secretary could order the CDC to do things. The CDC is within the department and under the secretary's control. But more importantly, once that vaccine is added, and we can agree to disagree on whether or not it's an external factor or an internal factor, the secretary is given complete discretion under 14E, complete discretion to set the injuries, disabilities, illnesses, conditions, and deaths associated with the vaccines and the time frame for those things. So under 14E, it is not just a solitary question. And even if she does not, or he does not have discretion with respect to the addition if this condition is met. There's absolute discretion with respect to the changes and the injuries.
Can I ask you to tell me or tell us why the Federal Circuit in the Tehran case got this issue wrong? I mean, you rely very heavily on the dissenting judge's opinion in that case, but I want you to talk specifically about why that analysis was incorrect.
The Tehran decision was incorrect for two reasons. Number one, well, a number of reasons, but the primary one is that if you read the Tehran decision, it says that amend does not mean amend. And that just simply is sophistry. Amend, as stated in the Act, it says specifically that the Secretary may amend, modify the table itself. Now,
Well, let me ask you this, I guess a practical question.
Mhm.
What do you think, under your analysis, it seems to me that every time a new vaccine was developed, that Congress would have to act to modify the statute to include it in the table, right? Or what do you mean? What's the alternative if this isn't the logical way to add vaccines or modify the act?
because Congress, in the first instance, put the vaccine table in the law, when they gave the Secretary the authority, it was to change the law, to amend the law, and that violates the presentment clause.
So under your view of things, any amendment, any vaccine addition has to be done pursuant to a congressional amendment or a new?
Yes, but Congress could have fixed it. They were in a,
And so why isn't the Controlled Substances Act unconstitutional? That's been applied for years, and the DOJ adds substances to that with the authority of Congress.
and I believe that that too is unconstitutional, but frankly, I have not
Isn't
looked
that a
at.
pretty big reach? I mean,
Well, I mean, and it may well be that has no non-severability clause. I think the fact that there's a non-severability clause here
well, that just
was,
gives you a leverage on the whole statute, but you still have to find something unconstitutional.
correct.
The idea is that Constitution confers the legislative power to Congress, but it clearly has a power to delegate some discretion in the administration of its acts, and that has been going on for a long time. And the question is whether a list that is subject to the congressional enactment can be adjusted through regulation. And basically, your proposition would say that just cannot be done.
Correct. If the act says, gives an executive branch actor, in Clinton, it was the president, here it's the secretary, the right to change a statute, which is what this does.
Well, that's the conclusion. It's the question is the statute's really not changed. What's changed are the subject matter of the vaccines and medicines that are covered by the act, and that's a long list. And
well, it wasn't a long list to begin with. It was 4 specific vaccines, and had the original act said we're giving this to the secretary to do by rulemaking, it wouldn't have been a problem.
Well, it does say that it's an initial table, so that suggests that it will be changed in the future. It's not set in stone. It actually provides procedures for adding. And you said earlier that it was completely discretionary, but as I see it, the secretary is actually required to add vaccines that are recommended by the CDC for routine administration. And so that doesn't leave much discretion.
In that word, the adding is not discretionary.
Well, that's what happened here, was adding.
Okay, but
We're
then
not
you
in
have
a
to look,
situation where it's deleting, which I think could be a different question, but here it's adding.
and you have to look at B and C of section 14E, because B says that the secretary also has to add and delineate the injuries, disabilities, illnesses, and the timeframes. And in fact, the secretary never did that. The secretary never did rulemaking initially to add the HPV vaccine, and didn't even follow this, but had discretion as to what injuries to
Well,
add.
If you were complaining about that, then you would be attacking the regulation, the executive action, but you wouldn't be attacking the constitutionality. The
Well,
constitutionality of it is framed by the statute and the delegation, the lawful delegation or not
and when,
of executive power.
and when it says that the secretary shall amend, that puts the legislative responsibility into the executive branch. And that's what Clinton doesn't allow.
All right, thank you, Ms. Bronson. You have some time left for rebuttal. Counsel, at the risk of butchering your name, I'm gonna let you introduce yourself. I don't want to get it wrong.
Good morning, Your Honors. Edward DeMolin for Merck. May it please the court.
Good morning.
When Congress passed the Vaccine Act in 1986, it confronted a crisis in public health. Vaccines prevented thousands of deaths every year, but rising lawsuits had driven manufacturers out of the market until only one maker of a key vaccine was left in the US. The Vaccine Act made two major changes. First, it created what's commonly called Vaccine Court, a mandatory compensation program that's funded by manufacturers through taxes on their vaccines. The act also imposed significant tort liability protections for manufacturers. For nearly 40 years, as Judge Niemeyer noted, Congress's system has worked. But plaintiffs' arguments would undermine it, either indirectly or directly. First, plaintiffs argue they can file civil suits even though they did not file timely vaccine court petitions. But every court that's considered this question applied Section 11 of the Vaccine Act and barred suits like plaintiffs. A contrary ruling that either vaccine court or its deadlines are optional would frustrate Congress's goals.
If we were to agree with you on that issue, do we need to go any further?
Your Honor, I would defer to the court on that.
We'd like, that's great. We'd like your help.
What I would say, Your Honor, is that at very most, the court would address whether adding Gardasil to the program was constitutional.
I mean, the way, as I read your brief, there didn't seem to be any argument that we needed to reach this issue, even if we agreed with you on the statute of limitations question. Is that your point? Is that your position?
Your Honor, I don't see why the court would need to reach that issue.
The Supreme Court has said so, that we don't need to reach as a matter of fact, the preference is not to reach the constitutional issue.
Well, that's a good reason not to do it then. And I would, so.
I'm just wondering if that's your position. I mean,
yes, that's
it's
our
sort of
position.
strange that somebody is barred from bringing an action under a statute and then would demand that we decide the constitutionality of the statute rather than their qualification for bringing it. And this is not a jurisdictional issue on either case. Limitations is not a jurisdictional issue, and neither is a constitutionality. And so the question is, what is the preferred order of decision making? And the constitutionality of the statute is a major decision. It's something patrolling the in this case, the jurisdiction of two branches of government in a major statute that had been applied broadly for almost 40 years. And it seems to me, unless we were anxious to do it or unless it was pretty clear, but it's a little murky, isn't it?
Well, Your Honor, I agree with Your Honor that if you resolve this issue on the language of Section 11 and that plaintiffs are barred from bringing their suits, I don't see why there would be a need to go on to constitutionality. What I would say again is that
I would have expected you to be much more assertive and say, of course not.
Of course not. But what I would say again is I think if the court did feel a need to reach that in any way at all, it would just be to say, as to the particular act of adding Gardasil to the program, Congress itself passed a statute that the president signed, and there is not any difficulty with that. But I think that, I think you're right.
Well, I think that this is a facial challenge to the statute, not an as-applied challenge. So I think we would need, if we were to address the constitutional claim raised, we would need to address the constitutionality of the statute, not the particular act at issue here.
So, Your Honor, I think that the way it was framed below was certainly as a challenge just to the addition of Gardasil to the statute. I think that that has expanded in this court to something that's broader. But I'll go back to what Your Honor said earlier, that we don't see a need to address that issue at all. So,
And what about the statute of limitations claim? Is this the proper forum to appeal that decision? I would think it would need to be appealed to the Court of Claims.
yes, Your Honor, we completely agree. And that's found in Section 12 of the Vaccine Act. I think Section 12F in particular. The text of that provision says that the decision of the Court of Federal Claims, which certifies the vaccine court rulings, shall be final as to the matters involved. Congress then set out a comprehensive appellate process if petitioners want to take an appeal from that decision to the Court of Federal Claims, to the Federal Circuit, ultimately in some of these cases to the United States Supreme Court.
Bill, I think it's a little more dicey than that. It seems to me, if there is a substantive decision made by the vaccine court, that is something that could be raised de novo in a federal court. But to get into a federal court, the statute makes it a condition that you file a timely petition. So it's not the substance of the timely petition, whether it's timely or not. It's the fact of whether you have a qualifying petition at all. And the statute makes a petition, qualifies a petition that has to be filed within X number of days. And the agency found that that was not satisfied. And so the question is, now you have a fundamental question of exhaustion, as opposed to a sort of a res judicata argument where they decided it and we therefore won't decide it. I mean, if it's de novo, you review that de novo, we would decide it. But the question is, do we get the procedural posture of exhaustion de novo? And I think the issue's couched a little differently in that sense.
Well, Your Honor, let me maybe give how I understand how the scheme works, and I think it's consistent with what Your Honor just said.
Well, I'm posing it as a question. You can dispute it if you wish.
Okay.
Yeah.
So when someone goes to vaccine court, the petition is adjudicated. Section 12 says, as I mentioned, that the special master's decision is final. As to those matters decided, there's the appellate process for that. Then under Section 11A2, someone is barred and cannot file an action in civil court, and the action must be dismissed if they fail to file a petition either at all or fail to file a timely petition. Now, so the decision of the special master on the timeliness issue, which is, a process issue under the Vaccine Act and that program, would be something that can't be revisited under Section 12F. And again, there's an appellate process for that. I think that's fundamentally different from issues like causation, substantive issues, as Your Honor described them. And the reason for that, I think, is pretty clear. A tort action applies completely different rules related to substantive issues like causation compared to vaccine court. So for the timeliness issue, the plaintiffs are saying, well, when we refile a case in civil court, somebody should reapply Section 16 of the Vaccine Act and redecide this issue under the Vaccine Act of whether we were timely. And that is not permissible. On the other hand, if they come in and say, well, under civil law, for a civil tort claim, we can have, new discussions about causation and things like that, that's fine. That's a different issue because it's not under the Vaccine Act, it's under tort law. I'm not sure if that's.
What do we do with this footnote in the special master's decision suggesting that the plaintiffs can go to civil court, go to federal court and reject the judgment? I found that strange.
So, Your Honor, I'd have to look back at that, but I think
what the special master says is that the petitioner can file not later than 90 days after the date of this court's final judgment, essentially appealing the judgment. But what you're saying is that's not the case.
So, Your Honor, I'd have to take a look at that. I could be mistaken, but I think there's boilerplate language that's put into all those decisions that kind of says the same thing. The appeal that's referred to may be the appeal to the Court of Federal Claims, to the Federal Circuit. As I said, I think ultimately the Supreme Court. But I don't think that there's anything the special master said that was at odds with the language of the statute. And I think the language of the statute 11A2 is what controls.
And it controls with respect to every single one of the plaintiff's claims. There's a long list of fraud,
Yes. Yes.
every
Section
one of them. So you're saying that every claim that they've brought is barred by the statute of limitations.
every claim. Yes. That is not disputed. It was not disputed below. It's not disputed here. What I mean to say by that is that the plaintiffs have not argued that there's some distinction as to some claims versus others that they say are not captured by Section 11A2. And I think that's consistent with the language of that statute and the unanimous decisions interpreting it. We cited several cases that have interpreted it the way that we're arguing for, McDonald and Hebern and Getz and others, and Powers, and they've all done exactly what we're asking for, which is to say, when the vaccine court says that somebody filed a petition that's not timely, they say, well, that's a process issue under the Vaccine Act that the special masters are to decide. If they've been rejected from vaccine court on that, we are not going to revisit that issue. We're going to honor the text of Section 11A2 and say that the case must be dismissed. And that's what we're asking the court to do here. I think it's completely consistent with the statute. Beyond, I would mention very briefly that even if there were, it doesn't sound like even if there were some question related to that, the district court obviously found for us on an alternative ground, which is to say that even if the plaintiffs were allowed to argue equitable tolling, he still would have dismissed their claims. And they did not raise that point in their opening brief in this court. The only argument that plaintiffs made on reply is that they wanted discovery about equitable tolling. And I think that is not a response to the district court's order. One of the things that the district court held, I think very cleanly, was that the plaintiffs could not show that their own clients had exercised diligence. And that is a requirement to prevail on any theory of equitable tolling.
We've actually gone farther. We've had 5 or 6 cases starting back with Harris versus Hutchinson, and noted that when Congress sets a statute of limitations, that cannot be set aside lightly. And equity can do it in very rare circumstances. And we have had, over those years, we've said the person's ignorance of something doesn't count. It has to be some intervening third beyond the defendant interfering and preventing the filing of it. It's a very narrow doctrine if you trace it back. I didn't see counsel on either side tracing the doctrine back, but it seemed to me that the arguments they advanced in support of equitable tolling have been explicitly rejected in our cases over the years since 2000. And so they carry the burden. They ought to at least have a proffer, I would think, on that. But that's a hard hurdle a hard barrier to hurdle. I don't want to preclude argument on it, but it seems to me it requires an analysis of all our case law going back, and where we said limitations mean what they mean, and equity will set it aside, and never on the excuses of the plaintiff, the personal excuses, subjective feelings, knowledge of the law, counsel's malpractice. All these things have not set aside statutes of limitations. And so,
yep, I agree with all of that. And I would just say,
one thing your friend on the other side points out is that one of the appellants was actually vaccinated as a child, and suggests that we should take into consideration age in our diligence analysis. How should we approach that particular fact pattern?
Well, Your Honor, the plaintiffs have not argued for a minority tolling rule either below or in this court, and that's because it's very clear under the law of the Federal Circuit that the Vaccine Act did not provide such a rule. I think there's the WJ by RJ decision that was cited, I think, by the district court below. But I think to step back a little bit, Congress passed this act, which is the National Childhood Vaccine Injury Act. I think it was pretty evident that there would be, children who might be using this system. And as the plaintiff's own authorities show, the case in Clore, Congress designed a very particular cutoff for the statute of limitations, which is to say that it starts with the first injury. It does not include a discovery rule. It doesn't, and there's certainly nothing about minor tolling, and no court has that I'm aware of, and none that plaintiffs have cited, has ever said that the Vaccine Act includes a minority tolling rule. So
If it did, it would probably abrogate the statute of limitations because it's the whole act is focused on children. As a matter of fact, we call it the Vaccine Act, but it has children in the title.
yes, Your Honor, I
don't know what it is, a national children vaccine.
Well, I guess under your view, even if that was an argument that could be made, and you say that there are cases that would bar it, that the place to bring it is not in district court after the fact, but in the vaccine court and up through the regular appeals process.
Yes, Your Honor. And so just to be clear, our argument is that first, as again, all the courts that have looked at this issue have said, Powers, Hebron, McDonald, this is not an issue to be revisited in civil court. This is an issue to be decided by the special masters related to whether the timeliness requirement was met. But I'm just saying as an alternative argument, and I think the district court put it that way in the opinion as well, that Judge Bell said, if I were empowered to rule on this, here is how I would rule. And he said he would still find that equitable tolling was not permissible here. I can respond very briefly on some of the constitutional points, unless there are any further questions about the timeliness issue. Okay. I would say very briefly that we do think that plaintiff's argument would mean a wide variety of routine legislation would be invalid. The Controlled Substances Act is one. Other examples that we included were statutes related to veterans benefits, things that are part of the Medicaid program. I think it would create an enormous set of changes to the entire legal system to say that this very routine piece of legislation is unconstitutional. And then I think there's just one point that I'll respond to on the substance. I think that the point about Congress amending the table, the majority in Tehran pointed out that when there are changes made to the table, the old table still applies to people who filed petitions at an earlier time. So it is a new table that's promulgated that is created by the secretary, and the old one still exists in the statute. The majority kind of explained further why that's the case, and I don't think there's any issue with that.
Can I ask you about your colleague's argument that the statute essentially leaves the secretary with unfettered discretion? That obviously was an important fact in the Clinton line item veto case, where the court said that one of the things we look at are the constraints that are inherent in the statute in deciding whether or not the statute would be constitutional. So what are the constraints in this statute that you say belie the argument that your colleague on the other side is making?
Well, I think for Section 14E, which is how Gardasil was added to the program, there are two major constraints, which are that the CDC has to recommend a vaccine, and then that Congress has to pass an excise tax that approves adding the vaccine to the program. And I think that Congress adding the vaccine to the program through passage of a statute that the president signs, I think is frankly enough to take the presentment clause issue off the table altogether. But in addition, it's obviously a considerable check on the secretary's discretion. If the vaccine can't be added to the program unless Congress passes a statute, that's the date that it becomes effective in the program. Then I think as to the other, so I think that's kind of the important point for this case. So,
When was Gardasil added to the tax?
it was, so the tax was passed by Congress at the end of 2006. I think it was signed by the president in December, I think December 20th of 2006. And then that was made effective in early 2007. So it was a long time ago. And then I'll just say a couple of sentences about the 12C order. I would say the court certainly doesn't need to address that. It has nothing to do, this is the motion for judgment on the pleadings. It has nothing to do with why these plaintiffs lost. Further, it has been raised again in bond, which is a pending appeal of the MDL court's summary judgment order on the bellwether claims. So it'll be before this court again in a setting where I think it can be addressed, but it has nothing at all to do with why the plaintiffs here lost in the district court. And so for all those reasons, as well as the reasons in our briefing, we would ask that this court affirm the decision below. Thank you very much.
Thank you, counsel.
I'd like to turn now to the issue of the timing. I think, Judge Berner, your question was absolutely on point, which is why did the special master say that you can always start a new action in federal court? And that's because the plaintiff is not required, petitioner is not required to go up through the federal circuit. In order
You're not required to go through the federal circuit, but you're required to file a timely petition.
Yes, but when
And the petition can be rejected, and if the petition isn't decided, you can go to federal court.
correct.
The default 240-day thing. But the statute is clear. You need to file a petition.
And these plaintiffs did file a petition. And when
Now,
the
it didn't
petition,
qualify as a petition, it was dismissed because it was untimely.
but it was dismissed, but it was still a petition and it was dismissed. It was not jurisdictional. And
No,
the
it's
floor,
not, I'm not suggesting jurisdictional. I'm talking about qualifying. In other words, you have to file a timely petition to qualify. And the whole purpose of filing that petition is to invite and encourage claimants to go through the process.
but if,
And it's being frustrated regularly now these days. I mean, what they're doing is they're filing the petition, waiting 240 days and opting out. And that isn't really the design. I know it's designed to protect against bureaucracy, but in this case, we're not talking about that. In this case, we're talking about a timely petition.
right. And the question is, who gets to decide the timely petition? When the special master says it's not timely and the person,
Who's the petition addressed to?
and the and the plaintiff rejects the special master, as the special master said, if you reject my decision, you may go to circuit court with a de novo case. And that's what the cases say. It's a de novo case. And so it was up to the court below to look at it anew. And if he had looked at,
Except the statute, I guess it's, what is it, 16.1, says that no petition may be filed. It basically is a condition for the petition's filing that it be timely.
and we are saying that it is the district court in the new case who is required to look at it de novo, not decide.
The action de novo, but not, they don't review the procedural timing of the petition. I don't see.
Well,
there's a lot of difference,
I think that's precisely what the special master said, and that's how the whole system is set up.
Well,
In fact,
I'm sorry to interrupt, but whatever he said, it has to be supported by the law. And that's the argument.
And-
If that was boilerplate, that was intent, that was there by mistake, then it doesn't have any legal effect. It has to be supported by the statute and the intent of the statute. So what's your position with respect?
my
to that?
position with that is that Section 12G and Section 21 both have the avenues for going to court in a de novo action. We have cited many, many cases that talk about the fact that the entire action is de novo.
Is there a case that
and-
you've cited that in this context where the case is dismissed because it wasn't timely filed?
No, we don't have one, but Clore
Why do you
decided,
think that's the case?
because I don't believe that I don't know. I don't know. It just hasn't, I don't think it's come up. But what I think is important, which is in the act, is in section 23, it says in any stage of a civil action. So they're talking about a civil action, just like the one that was brought in the district court below, the vaccine injury table, any finding of fact or conclusion of law of the federal court of claims or a special master in a proceeding on a petition filed under section 11 and the final judgment of the federal court of claims are not admissible. They're not admissible for any purpose, which shows that the act was intended to be de novo. And we believe that
So
had,
assuming that we agree with you
Mhm.
for the sake of the argument, how is your equitable tolling argument not simply a repackaging of the discovery rule, which has been rejected?
well, first of all, we did not get any discovery. In the Vaccine Act, you don't get discovery.
Well, I think the discovery rule is, I just discovered that these two things are
No.
connected. So therefore, wasn't bound by this statute of limitations because I didn't know that these symptoms that I'd had all of these years were connected to the vaccine that I received years prior.
No,
So my understanding is your argument is, well, they couldn't have filed earlier because although they'd been suffering from all of these various maladies that were connected to the vaccine, they had no way of knowing until just before they filed that there was this medical connection between the vaccine and the maladies. Is that not your argument?
no. Our argument is that under Fourth Circuit precedent, we believe that there are two aspects of the equitable tolling. The court below did not consider equitable tolling at all. And under Cruz and under Lowe's, not only are there extraordinary circumstances that you need to look at, but you also get an opportunity to look at the defendant's conduct to see whether the defendant's conduct affected the ability to go forward with the claim. And under
Well, we've stated in about 2 or 3 opinions, I'm just looking at Sosa, looking at Hutchins. I mean, Sosa, a petitioner's own ignorance or mistake does not warrant equitable tolling. And in Harris, we talked about anything that's located with the even malpractice where the plaintiff is misinformed by the attorney is not equitable tolling. It has to be something external, and it has to be a rare circumstance. This is not a subjective excuse thing. I mean,
understood. And we believe that we should have gotten discovery of Merck below.
we said in Harris, to apply equity generously would lose the rule of law to whims about the adequacy of excuses, divergent responses to claims of hardship, and subjective notions of fair accommodation. In other words, the notion is that all of those things do not justify equitable tolling. What we really looked at are things beyond the plaintiff's control, something that prevented the plaintiff from doing it, or conduct of the defendant, maybe. There's nothing here to suggest that the claims were concealed. You guys cited literature from 2016, no, it's 2006, starting with 2006 and ending to 2020, a continual stream of literature addressing this, and lawsuits were filed beginning in 2016. So this is not something that was concealed.
But we didn't get a chance to do the discovery and have the district court look at the findings.
You didn't proffer anything. What would you?
We had tried to proffer and we were not given the
You
opportunity.
didn't even proffer in your brief.
We tried below to try to get the court.
All it takes is to add a paragraph, and this is what we would have shown.
If I may answer one question,
You
Judge,
can respond to Judge Niemeyer's question.
pardon?
You can respond to Judge Niemeyer's question.
I thought I had,
Okay.
That's fair enough.
I was going to ask, respond to something that Judge Niemeyer had asked earlier as to when the tax was passed, for purposes of my opponent's argument about the Constitution. And the tax was passed in 2006. At that time, the secretary hadn't done anything. So it wasn't as though the tax could possibly have ratified anything that the secretary had done, because the secretary didn't act until 2007, and at that time didn't pass rules, and didn't pass rules till 2011. So The secretary didn't do what even the statute required.
So the manufacturer of Gardasil was paying a tax since 2006 to 2011 and did not apparently get protection of the act
Oh,
until
no.
2011.
No, got protection. What the secretary said was, you get complete protection, but since I'm not putting on any injuries fully within the secretary's discretion, it was a completely unbalanced
I'm talking
system.
about the protection of the act. In other words, it's not listed on the schedule, if it's listed on the schedule, then you get protection.
The secretary said in 2007, I am going to make it effective as of February 2007, even though I haven't passed rules and even though I haven't put it on the schedule and even though I don't put it on the schedule to 2011. So
But this just challenges a regulation. This doesn't go to the constitutionality.
Well,
Congress passed the law making it clear that Gardasil is going to be part of the program in 2006 by taxing it.
well, nothing in that taxing law said anything about it being put on the table. Absolutely nothing. And in fact, when they put Gardasil on that table in 2011, retroactive and effective in 2007, it gave Merck all of the protections, but gave the plaintiffs none of the benefits of a speedy opportunity to get compensated for a table injury.
All right. Thank you, counsel.
Thank you.
I want to thank both counsel for their arguments this morning. We appreciate your being here and for your able representation of your clients. We'll come down and greet you and then move on to our second case. Those who are remaining in the courtroom can be seated, and then we'll wait for the students to come back in. All right. Our second case is 24-4169, United States versus Allen. Mr. Cooley?
Morning. May it please the court. My name is Craig Cooley. I am CJA counsel for the appellant, in this case, Ms. Carlisa Allen. In Ms. Allen's opening brief, I raised multiple sufficiency claims, particularly regarding counts 3, counts 4, counts 5, and the 841B1C sentencing enhancement that was attached to the sentence in count 1. The court doesn't have any prerogative as to which claim. I plan to address counts 3, 4, and 5 first. Counts 3, 4, and 5 deal with the arrest, Miss Allen and her co-defendant, Cy Frazier, on March 15th, 2023. And during the arrest, Mr. Frazier had a camouflage book bag. Miss Allen had a coach bag. And when the task force seized and searched Mr. Frazier's camouflage book bag, they seized $12,000 in cash, a digital scale, over 8 grams of cocaine, over 7 grams of fentanyl, and 70 oxycodone pills. In Miss Allen's coach bag, they found 2 small baggies of cocaine, which I believe totaled cumulatively 1.16 grams. We found a straw, and in regards to count 5, they
also found a gun,
yes,
and they found packaging in the console.
they did find packaging in the center console,
And that packaging was sort of unique. It was sort of their brand, the little packages, Ziploc bags, with half-gram packaging.
Yeah, I'll come out and say it, like I said it in the brief, is that the government had them dead to rights for count 1. I mean, there's 22,000 pages of text messages, evidence that there was a conspiracy where Miss Allen and Mr. Frazier were manufacturing cocaine, splicing it with fentanyl, and selling it to Duke and UNC students. I'm not going to argue that point.
So as to 3 and 4, my understanding is that your argument to be that your client didn't have sufficient control over the backpack, that the contents of the backpack shouldn't be counted. But what do you do with this court's decision in Moody, where that talks about the driver of the vehicle having control of the vehicle, and that's sufficient to establish constructive possession of anything in the vehicle? This was her car. She was driving. I watched the dash cam video.
Let's talk about each count. Again, count 3 focuses on the cocaine that was in Mr. Frazier's book bag, which was over 8 grams, which is a distribution amount of cocaine. Agree. The coach bag had a much smaller amount, personal use amount, 1.16 grams. And the indictment for count 4 is the fentanyl. And the only packaging, or the only thing that had the fentanyl, was the camouflage book bag. So the question is,
was there fentanyl in her?
No, Your Honor.
But in this book backpack that you're calling a book bag, there are text messages, as I understand it, between the two that were in these text messages were in evidence, and they discuss putting the drugs in this backpack. And so it seems that both of them used the backpack.
That I would respectfully disagree. I don't think there's any photographic evidence. I believe she knew that it was
22,000 text messages. They put in 8,000 or 800 or whatever in evidence, and they cited as just a casual matter a whole bunch of text messages where they talked about. He asked, "Where is this drug?" And she says, "Well, you put it in the bag." And then he asked, "Where?" And she put stuff in the bag, in the front pouch. And that bag was the conspiracies, the business. He talked about this business. Look, we have a wonderful business, albeit illegal. And the center inventory holder of that business was the bag. And the reason I ask you about the packaging is that bag didn't contain any packaging. When they seized it, it came in with distribution amounts of fentanyl and cocaine and scales. But he would still have to have the packaging. The packaging was in the console and the protection was under the seat in her car. There was no, I don't think it's beyond any doubt that she knew that bag was the conspiracy bag that they had used over the whole time. She knew what was in it. She knew what was where things were. He asked her. She says she put stuff in. He took stuff out. And he kept it at the barbershop, didn't he? I think there was
He
evidence.
kept
of
it
that.
with him at his
Yeah,
his
yeah.
place of residence.
And so he gets in the car and he throws it in her lap. And there's no mystery about that bag.
I would respectfully disagree. There is a mystery because if you look at how they charged and presented their conspiracy, they had students come in, they had testimony that, you know, they were meeting students on that day, particular day. Take count two. In count two, they charged Miss Allen with
I know, but
distributing.
see, you're skipping a very important point, which is the centerpiece of your argument. Your centerpiece of your argument is what they discovered at the arrest.
Yeah.
In the bag is not attributable to her. That's your argument.
That's my argument. No,
Yeah.
that's exactly.
And my point is, if you look at the whole record, you see that that bag was not just uniquely his, and he's carrying, and there's a mystery when he threw it in there. That bag was the business bag, and she was involved as deep as he was. She mixed, she put her on the scales. She told him what was in the bag, where it was. He would ask her about the bag, and she would say, "Oh, you put that in the bag last night," or this type of thing. And there's a bunch of those which are not being addressed. And I don't know why that bag was the center tool. It was the closet or the storage closet of the cabinet where they stored their stuff for their business and mutual business.
Everything you're saying is correct, and that all goes to count one, though. You're talking about this.
No, it
grand
goes to
conspiracy.
count three because he's now charged with possession, constructive possession. It's in her car, and she knows where it is. It was in her lap, and then she put it in the driver's seat before they arrested her. He threw it in the car, but this was not just his private pack where he kept books or he kept his underwear or whatever you carry in book bags. I guess you're supposed to carry books in book bags, but this book bag was this drug distribution bag that both of them used.
I would respectfully disagree, Your Honor. I don't think
Okay.
there's nothing in terms of with all the students who testified, particularly when Miss Allen would make the delivery. There's no testimony that she ever had the book bag.
It doesn't matter because at that point she has arrangements to deliver certain packages and she's carrying those packages. And those packages are very small. They're like this. And on the day of the arrest, those packages were in the car. They were in the center console. And he carried the scales and he carried the drugs in gross amounts. And she carried 2 packagings in her purse that were cut already. And she had the gun.
Well, she legally owned the gun too.
Well,
Let's
it's not
say
a question of whether she owned it or legally owned it. The question is whether she used it in connection with the distribution of drugs.
there's also another component to this is that
Before you get to that, can I, I'm
Sure.
sorry to interrupt you, but even if you were to discount everything that Judge Niemeyer said about this long-term drug conspiracy, can I take you back to Judge Berner's question about our Moody case? I mean, this is her car, right? So why wasn't the jury entitled to conclude that as whether she actually possessed the bag or constructively possessed the bag, owner of the car, she constructively possesses everything that's in that car?
the bag, if you look at the fact pattern, is the bag was, it was in the car only to the extent that once Mr. Frazier saw the task force members approach him to make the arrest, he frantically tossed it to her. She placed it on the front seat.
It wasn't in the,
It wasn't in the car. You have to visualize, the task force members are, after Mr. Zinner's death, they sort of expedited their investigation. They scoped out the lion's den. They see Miss Allen pull up to the lion's den.
He was in the car with her.
No, they were walking to the car. They were walking to the car when they got arrested. They walked to the car and
Well, I don't know. I think the record might show something else, but let's assume that he was in the car with the bag and tossed it to her and then gets arrested. If the bag is in fact in the car, doesn't our Moody decision suggest that a jury could find that she constructively possessed that bag?
constructive possession is about control and dominion. She didn't, again, I don't think there's no evidence in the record that she might have known of the bag. There are text
She
messages
knew of the bag. She had it in her lap.
because he threw it at her.
I don't care she had it in her lap. That's the fact. And then she took it from her lap and put it in the car seat. Right?
Constructive possession also has to be voluntary too. If I throw you something and you catch it,
That's actual possession, actually.
I mean, but the government conceded. I mean, got to the point of almost a concession that Mr. Fraser had the bag and he threw it at my client. So my question is that a voluntary action? If somebody throws something at me, am I just going to let it hit me? Is that a voluntary action? And my argument would be involuntary.
Well, you wouldn't be guilty of distribution if you didn't know what was in the bag.
That was my second argument, is how does I get it. There is this grand conspiracy, but the indictment is specific. It's on this day that they were going to distribute these drugs, March 15th, 2023. And the point, my global argument is this, is that the government is using their business relationship to impute knowledge, perpetual knowledge in a perpetual conspiracy. Anytime these two were ever together.
Count 3 and count 4 charge both of them.
Yeah.
Not a conspiracy.
Not a
Actively and in aid of each other.
Yeah.
Charge both of them with possession of cocaine and fentanyl, count 4, of sufficient amount to violate the statute. On that day, both of them participated he had the inventory in the bag. The bag was taken from the car by the officers. She was in the driver's seat. She had the packaging in the console. She had the gun in underneath her seat. And the question, we have all this background history for 2 years. They've been doing this. She's been mixing it. And here they are carrying out another act on the date of their arrest. Now, I don't know why both of them are actively participating in possession of those drugs for distribution. I mean, just because she was carrying the gun and he's carrying the bag, and then it ends up in her car, and that's where they find it.
I'm saying there's nothing in the record that imputes, what knowledge do we have on that day that when she picked him up?
Well, the dash cam video that I watched when they were arrested showed that she was driving, he was a passenger. Police came from either side, the car was stopped,
Yeah.
and they both were one by one removed from the vehicle. And at that point, he threw the backpack back into the vehicle. So the backpack was in the car with the two of them while they were driving to wherever they were driving to. And the backpack was in a car that she owned and had possession over, dominion. She was driving, she owned the car. So it seems to me that
If
Moody
you look
controls.
at the totality of the evidence that day, when she was picking up Mr. Fraser,
I thought you said he didn't get in the car.
when she went to the Lion's Den.
I understand, but my question was, he in the car?
Yes, he's in the car. I got that
Okay.
wrong.
And he's in the car.
He's in the
with
car for a
backpack.
very brief moment, and then, yes,
And she's in the car.
yes.
In the driver's seat.
They
He's in the
immediately-
backpack in his lap. And they have the gun and they have the packaging, and she has her purse.
Yeah.
And they're together in the car and they get arrested. And now as he sees them coming, he flees, leaves the backpack behind, tosses it in the car, leaves the
Throws his-
backpack behind and runs.
He throws his phone into the car.
Throws the phone under the car and runs. Now, it seems to me
She didn't run.
that's constructive possession.
Well, I would say, I mean, you could draw an inference that he ran. He knew it was in the book bag. Did she know? That's the whole argument, is like, did she pick him up that
But
day?
now you're falling back on whether she knew, and that goes to my point, is the bag was basically uniquely the storage closet.
But
for
I
their-
mean, is it, what evidence? I mean, that's the point. Is there the perpetual knowledge? Like, if I pick up my
It's not
boyfriend.
perpetual knowledge. It's the fact that they constantly talk about the bag. Where is the stuff? Oh, it's in the bag.
But is the bag
You
always
put it-
containing the stuff? I mean, if I have a backpack that I use,
There's no
Is that
evidence
drugs?
otherwise, because the numerous emails talk about drugs in the bags, drugs taken bags. Do you have these drugs? No, they're in the bag. You put them there last
they're in
night.
your book bag.
Your book bag. Well, yeah, but it's the book bag. It's his ownership, I gather, but that was used by the two of them. She put things in there. And he said, "Where is it?" She says, "In the front pockets."
And that,
I
again,
mean-
if you look at the count two, and when any of the students testified as to when Miss Fraser would deliver, there was no book bag. A.
Because you don't deliver from the book bag. The book bag was the inventory, the scales, the gross amounts of fentanyl, the gross amounts of cocaine.
My,
And so the question is that she carried two packagings in her purse, and she carried empty packaging in the console.
but there were, if talking about the items in her purse are much different than what is in that book bag.
Well, it's
There's a strong argument that those two small baggies and the straw were for personal use. And if you read her pre-sentence report, she was using at the time she was arrested. She tested positive for fentanyl, cocaine, and
The
marijuana.
jury didn't know that.
Pardon me?
The jury
I-
didn't know that.
I agree. That's a post-sentence.
And
Yes.
the problem, Mr. Cooley, and obviously you're making the best argument you can for your client, is that those are great arguments, but why wasn't the jury entitled to reject them? And we're now on appeal, and the question is whether any reasonable juror could find for the government on the facts and the record.
Well, again, in the light most favorable to the government,
Right.
which you have to give.
So that's a real challenge.
I'm simply saying, when you have a relationship where you're not only a business partner with somebody, but you're also have an intimate relationship with them, is there a presumption that every time these two are together, they're together for a nefarious reason, or are they together for a personal reason?
Well,
I think
for a
if you-
personal reason, do you think he would have brought the book bag? If they were going out on
That's
a
all
date
speculation. It's all speculation. I have
not
definitely-
speculation,
It is
because we
speculation.
know what was in the book bag, and we know. the
We know
book
now,
bag
we
was
know
in the bag.
now. I'm saying, did my client know? What evidence did the government present to show that she knew? In all the other
She's
cases,
carrying a
the
gun
witnesses
under the seat.
testified, there's text messages that show that Miss Allen is going to make this delivery. When you look at the text messages from March 13th, from Miss Allen in particular, she's talking about picking up her kid, taking him to school. He's in the back seat. Why would she bring her child to a drug deal when she's never done that?
Why would she distribute drugs? I mean,
Well, there's a hierarchy of decision-making here. I get it. There's a hierarchy, but that's the point is when she picked up Mr. Fraser that day, Caleb, her 15-year-old son was in the back. What, she was gonna go pick him up and then they're gonna go make a deal with the kid in the back?
Okay,
That's one of the
look,
arguments, is that sufficiency.
The question is whether the jury could answer that and say they were. And the answer would be this: if it was just to pick up the child and he was riding along, he brings the inventory of the business along. She's carrying a gun. She's carrying packaging. She's got two samples in her purse that your argument is she could be using for personal use, but she was in the business of selling those little things. And so the jury can say, well, that trip wasn't just to pick up a son. That trip was for something else. I mean, they wouldn't have all that gear in there.
I'm saying it's speculation as to what my client knew. And that was in that bag on that specific day. That's the primary argument.
It's text messaging over
I know, but that
years.
But not on that day. They didn't, there's no text message that say, hey, Si, I'm picking
You
you
don't
up.
have to every day, but there's
Well, there's a lot, that's 22,000 pages of text messages. They're pretty good at texting when there in fact is a drug deal taking place. Just coincidentally, on March 15th, 2023, the government presented no text messages to say, or even strongly suggest that she was picking him up to go make a deal. That's all, that's it. So my argument is pure. I'm running short on time here.
You're overtime.
Time.
Thank you,
But
Mr.
that's the
Cooley. I'm going to
argument,
stop you
yes.
there. You've got some time for.
Thank you, thank you.
Ms. Williams-Durham, hear from you.
Morning, Your Honors. Tracy Williams-Durham for the United States of America. Your Honors, this court should affirm the district court's decision to deny the defendant's Rule 29 motions, as there was substantial evidence for a reasonable juror to find the defendant guilty of counts 3, 4, and 5, And likewise, excuse me, there was substantial evidence for a reasonable juror to find that the cocaine that was laced with fentanyl that Joshua Zinner purchased during the course of the conspiracy was the but-for cause of his death. And if I can just pick up where the argument ended regarding the drugs that were recovered from the book bag.
Can I actually ask you to address first the firearm count?
Yes, Your Honor.
You know, in Lomax, this court held that mere possession of a firearm is insufficient to sustain a conviction. And here, the district court did note that Allen legally possessed the firearm. I think a pretty high fraction of people in the state do own firearms, and there was evidence that she carried it all the time, that she had reason for that. She had been the victim of a home invasion and said she carried the gun with her at all times. So why here is this not mere possession? What facts were presented to the jury that would reasonably allow them to conclude that it was used in connection with the drug offenses?
Yes, Your Honor. Well, while it's true she did legally purchase the firearm at the time that she purchased it, at the time of her arrest, she was using it illegally. And I think
How do we know that?
Well, the fact that she was found with the firearm that was loaded with an extended magazine with one in the chamber underneath her driver's side seat, where she also had 2 bags of cocaine in her purse, and she had her business partner, Cy Frazier, in her passenger seat, who was carrying a book bag that was full of drugs that was instrumental to their drug dealing business, demonstrates the fact that on that day she was using that firearm to further the drug trafficking conspiracy. And Your Honors, there were several text messages between the two of them that was introduced in evidence in that 22,000 page thumb drive that was submitted back with the jury, where they specifically discussed bringing firearms along with them during the course of their deals. For instance, on February 24th of 2023, the defendant texted Cy Frazier, "Bring the black one if you need something now, because I didn't bring purple." And purple is referring to a second gun that they possessed, which was the color purple. They refer
What was the date of those texts?
that was from February 24th of 2023, Your
But the
Honor.
question is whether or not that Miss Allen was using the gun in furtherance of the drug trafficking crimes alleged in specifications 3 and 4, which occurred back in May.
Yes, Your Honor, but this is just providing some context that the jury was able to consider the fact that they did utilize a firearm when they were making their drug deals.
But what was the evidence that she was using the firearm in furtherance of their offenses that day?
Well, Your Honor, the fact that she was carrying it while she was also in possession of significant amounts of drugs and cash. There was about $12,000 that was also recovered from Cy Frazier's book bag that day.
So what evidence is there that the gun played a role in the offense? I understand that she was carrying the gun. I understand that she possessed it legally. You point out that it was loaded, but that's not illegal as I understand it in the state.
No, Your Honor, but I believe looking at the totality of the circumstances and the nature in which the gun was recovered, the fact that it was within close proximity to the drugs as well as to the proceeds of the drug sales that was in the book bag. And you did previously mention the Lomax case, and Your Honor, that case finds that a fact finder is certainly entitled to come to a common sense conclusion as to somebody being in possession of both drugs and a firearm on their person, and the fact that the drug is most likely there to aid in the drug trafficking. And that's what was apparent here, Your Honor. It wasn't just that she was riding around with a firearm that she legally purchased and nothing else. She was riding around in the blue RAV4, which all of the students who testified that that was the mode of transportation for both her and for her business partner, Cy Frazier. So they were in that vehicle, and while they were in the vehicle, she was in possession of drugs, her partner was in possession of drugs, there was packaging that was found in the center console. Clearly, the possession of the firearm that day was not merely for personal use, it was to further aid in their drug trafficking conspiracy. And Your Honor, even though there was the son in the back seat, which is something that counsel raised both in his brief and in his argument,
Yeah, let me ask, I'm sorry to interrupt you, but as I understand counsel's argument is that, even if the government had them dead to rights in the conspiracy, they were drug dealers, there's no question about that they're not drug dealers 24/7, and that sometimes this was a mom taking her son to apparently a PTA meeting, as I recall.
That's
And
correct, Your Honor.
that's, you know, the jury would have, in his view, the jury would have to speculate in order to find that on that day, they were actually engaged in their drug trafficking endeavors.
Yes, Your Honor, and evidence was presented to the jury regarding the text messages between the defendant and Cy Frazier that day leading up to the arrest about what they were doing. But one of the things that the jury was also able to consider was the circumstances that led up to count 2, which was the controlled purchase with one of the students, Matthew Warren. And if Your Honors recall, during that time, the defendant sold him approximately 21 bags. Again, the same small Ziploc bags of cocaine that she had in her purse and empty bags in the center console of her car that day. But Your Honors, the jury was presented with testimony from TFO Wilking, who actually conducted surveillance on the date of the controlled purchase with Matthew Warren. And he observed the defendant arriving to her apartment complex in the blue RAV4 with a teenage son also in her vehicle. Presumably that was one of her children. They both get out of the vehicle, go into her apartment. 5 minutes later, she immediately comes back out, gets into her car, and goes straight to the deal with Matthew Warren. And Your Honor, of note from that particular incident, there was a photograph that was taken, which was submitted to the jury, a surveillance photo from that deal with Matthew Warren, which was count 2 of the indictment. But the purse that she is seen carrying is the exact same purse that she was found with the day of her arrest that also contained the 2 bags of cocaine. So Your Honors, while she does have a personal life, while she may have been on her way to take her son to a PTA meeting or go to a PTA meeting for her son, that does not mean that afterwards she and her business partner, Cy Frazier, weren't going to go make a deal. And Your Honor, they were actually together the day before at the Lion's Den barbershop, which she and Cy Frazier texted multiple times about him housing drugs in the Lion's Den barbershop, but also students testified that sometimes when they would meet up with Frazier to purchase the drugs, they would meet him at the barbershop. So this was a place where both of them are aware has drugs, or that they store their drugs sometimes while they're waiting to sell them. So on the date of her arrest, when she was in the vehicle with Cy Frazier, they both had drugs on them. Clearly, it might not have been at that point in time that they were intending to.
Or even at that day, it could be. I mean, the text messages from that day suggest that they were going to an intended event at her son's school, and there was no evidence that shows that on that date they met to distribute drugs.
Well, Your Honor, I think it was a reasonable inference that the jury may make based on all the evidence that was presented that they were together the day before at the Lion's Den barbershop. So it's reasonable to think that maybe they discussed in person their plans for what they were going to do the next day, and that's why there weren't any text messages. And Your Honors, if
I think it's interesting that there were 22,000 text messages. It seems like these two excited about everything, and on this one day, there just happened to be text messages about an upcoming drug deal when they really texted about their drug deals past.
That's correct, Your Honor, but again, they were physically together the day before. There was surveillance taken at the Lion's Den barbershop of both of them together. So it's reasonable to assume that if they were physically together, they could have had a conversation with each other about what they were planning to do the following day. And Your Honor, they were actually physically together. Detective Camacho testified about the gas location where Cy Frazier was before he delivered the lethal dose to Joshua's dinner, and based on the cell phone data, the location data, their phones were actually the same. They were hanging off of the same towers, which was Timber Hollow Apartments, which is where the defendant lived. So they were also together with each other before he went and sold to Joshua's dinner.
I don't think there's any question that there was a drug conspiracy. I think my questions were raised were about the data you did for the arrest.
Correct, Your Honor. I was just highlighting that as an example that they are physically together because there was no text messages about him selling to Joshua's dinner on that date with Carlisa Allen. So it's a reasonable inference for the jury to have made that if they are physically together leading prior to some sort of drug deal or some sort of drug transaction, then there might not be text messages relating to that because they would have spoken to each other about it prior to actually making the deals. And Your Honor,
If we agree with your colleague about backpack, that Alan didn't start to possess it, do you think there's enough, is there enough evidence for the jury to have convicted on the drug offense without a backpack?
yes, Your Honor, because not only are drugs that were recovered in the backpack, there were also drugs recovered from her purse as well. And again, those drugs were packaged there, signature small, one by one in Ziploc bags.
Was there any fentanyl in that purse?
There was no fentanyl, Your Honor. However, the lab analyst did detect the agent in which she called PT hit, and I will call it that because I am unable to pronounce the actual name of the chemical product that was, but PT hit was indicated inside of the bag that also contained cocaine, and that also
Was there cocaine in those bags? Is that fentanyl? Was it cut fentanyl in those two packages?
there was no fentanyl that was detected in those two bags.
So it was cocaine and a cutting agent.
That's correct, Your Honor.
And didn't she test positive for both fentanyl and pain on the day of the arrest?
Your Honor,
And that just she had these drugs on possession for use.
well, I would highlight again that evidence was not presented to the jury. That was provided in the sentence report. However, I will note, Your Honor, that that is something that counsel referenced in his reply brief, page 11. However, he failed to include the next sentence from the pre-sentence report, which reads, the defendant admitted to use of marijuana, but denied the use of cocaine and fentanyl. She further stated that if the marijuana she smoked prior to her being released to control supervision must have been laced with illicit substances. And that's in the joint appendix at page 1086, Your Honor. So by her own admissions, she did not use cocaine or fentanyl. She only used marijuana. If Your Honor don't have any further questions regarding count 3 or 5, I'll turn briefly to the results of death enhancement. Your Honors, again, there was substantial evidence that was presented to the jury for them to be able to determine that the cocaine purchased by Joshua Zinner did have fentanyl in it, and that the cocaine and fentanyl he ingested that night was the cause of death. They heard testimony from the medical examiner, Dr. Heichel, who testified that she has been doing this for about 16 or so years and has performed several death certificates, and based on her evaluation of the death investigator's report, as well as the urine screen, the initial tox screen, and the full toxicology screen that came back, her determination for the cause of death was that it was accidental and that it was the result of a cocaine and fentanyl toxicity. She testified that both the cocaine and the fentanyl being illicit substances, once their introduction was made into the body, at that point it could not be ruled any sort of natural death, and any other type of illnesses would kind of be secondary to the cocaine and fentanyl toxicity, because the level of fentanyl
They were levels that were lethal, right? Both of them.
That's correct, Your Honor. She did indicate that with cocaine, there's not a determinate amount that could be determined to be lethal, given that it is an illegal and illicit substance and serves no medical use. But she did say that with regards to fentanyl, because it can be used medically, the recommended dosage is about 3 nanograms per milliliter. The amount of fentanyl that was found in Joshua Zinner's bloodstream at the time of his death was 11 nanograms per milliliter, which she said is over 3 times the medically prescribed dosage, which is only when it's medically prescribed in a very controlled and safe environment. Here, and in particular, Your Honor, she did indicate that the manner in which it was likely ingested by snorting through the nose would have then entered the bloodstream and therefore gone to the brain very quickly. And at that point, she ruled that the fentanyl and the cocaine both were the but-for cause of his death and were independently sufficient to cause his death.
So with respect to that, there was no autopsy. This is a fairly young man, no indication of any health issues. But on the other hand, we don't know for sure, right? Because there was no autopsy, and don't know whether or not there might have been something else going on that might have potentially been a cause of his death. But as I understand your argument, that really doesn't matter because the ultimate conclusion is that this combination of drugs certainly would have caused his death.
That's correct, Your Honor, and that's what Dr. Heichel testified to. She did explain that the Office of the Chief Medical Examiner did have to change their protocols in how they evaluated the death cases that were coming before them, given the COVID pandemic and the opioid epidemic, which was creating a substantial backlog for them. So as a result of that, they had to change their procedures, and what they did was do an initial screening where they had a death investigator go out to the scene and evaluate the scene and determine whether or not it was suspected that there was a drug overdose that caused the death. If that was correct, then they would do a urine sample and initial tox screen. If only marijuana came back as positive, then they would move forward on an autopsy. But if there were other illicit substances, such as here, where there was high amounts of cocaine and fentanyl that were found in his system, then they can do a screening in lieu of an autopsy, where the medical examiner still did a visual examination of the body. She reviewed the report that was provided by the death investigator.
Did they find didn't they find a packaging near his body?
Yes, Your Honor. So at the time of the death, there were 3 Ziploc baggies that were, again, in that same 1-by-1 Ziploc size bag from the conspiracy. 2 of them were empty, and 1 still had a little bit of matter in it, which was submitted to the laboratory and came back as positive for cocaine and fentanyl.
But also found near the body was amoxicillin, and there was testimony from at least one expert, as I understand it, that the death could have been caused by an allergic reaction to amoxicillin.
That's correct. There was a bottle of amoxicillin that was found on the bedside table.
And amoxicillin was found in Zinner's blood as well, is it not?
I'm not certain if it was found in his blood, Your Honor. I know that that was not something that Dr. Heichel considered to be a contributory cause of his death. We had the jury
Did Dr. Heichel even consider the possibility that could be an allergic reaction to an antibiotic that caused the death?
Well, Your Honor, Dr. Heichel testified that if there was a positive test, that she would get notification of it, because the full toxicology panel would test for numerous substances. She would not get all the ones that came back negative, but she would review the ones that came back positive, and she would evaluate all of that in making her determination. But I will say, Your Honor, that presented to the jury was testimony from Dr. Mears, who was Joshua Zinner's his nephew, his uncle, but he also was his pediatrician and worked at the practice that Josh attended for most of his young life. And during that time, he testified, and medical records were introduced into evidence that he prescribed Josh with amoxicillin about half a dozen times. And over the course of those administrations, Josh never had any type of adverse reaction to the amoxicillin that he was prescribed. There was no sort of allergic reaction or any indication that he was allergic to the amoxicillin. And Your Honors, even the defense's own expert testified that while he couldn't make a definitive determination as to what the cause of death was, there were 3 possibilities. The first was some sort of anaphylactic shock, which could be due to an allergic reaction to the amoxicillin. The second would be cocaine, and the third would be fentanyl. And because the jury was presented with sufficient evidence that Joshua Zinner did not have any allergies to amoxicillin, then that negates the defense expert witness's first theory, which was anaphylactic shock, therefore only leaving the 2 other theories, which are consistent with what Dr. Heichel testified was her ultimate determination as to the cause of death. And that's also consistent with all the other evidence that was presented during the course of the trial.
All right, thank you, counsel.
Thank you, Your Honors.
Mr. Cooley, you've got some rebuttal.
Just a couple follow-up points. Based on the panel's questions to my colleague, I think the panel gets the gist of my argument, Ms. Allen's argument, that yes, there on March 15th, 2023. And again, even when viewed in light most favorable to the government, I still believe it's pure speculation as to whether Ms. Allen knew what was in that book bag, even if she knew that.
Can I ask you in response to that argument, but she was also charged with Section 2 violation, aiding and abetting. What's your response to that? In other words, that would not protect her from an aiding or abetting violation, would it? Lack of knowledge.
Aiding and
If
abetting
she
is-
aided and abetted knowingly in other aspects of the distribution on that date, then she would be guilty as a principal, would she?
Well, it goes back to knowledge. I agree. If she knew that what was in the book bag, then you'd get her on. I wouldn't be arguing. Right? It works both ways. It all depends on what is her knowledge and what evidence is in the record to show that on March 15th, 2023, that when she picked up Mr. Frazier, she knew that he had a tremendous amount of drugs, distribution amount, a digital scale, $12,000. Right? It's pure speculation. Yes, was he using the book
Well,
bag?
that's very specific, but the question is whether she knew that that was the drug carrying bag. And there was plenty of evidence for a jury to conclude that that bag was used over the period of time as the drug. It was referred to in their exchanges as the bag. And in each case, it was referred to as where are the drugs, which pocket, do you have them? No, they're in the bag. Where did you put those? I put them in the front pockets. The bag apparently was a tool of the conspiracy. And while she may not have known specifically how much money was there, she knew it was the operational inventory carrier.
But I agree. Under Section 2, though, and I believe I said
Yeah, Section 2. I was just asking that as a question because there is a Section 2 allegation.
Yeah, there's a Section 2, and I cite a case of the Second Circuit that says there's Section 2 counts are really indictment specific. It's not about
Yes,
the grand
no, it's
conspiracy.
probably count specific.
It's count specific.
Yeah,
And
yeah.
again, it goes back to the knowledge argument of when she went and picked up Mr. Frazier that day, right? What did she know? And moreover, when you talk about aiding and abetting, what affirmative action did she take to aid and abet him?
She's driving them.
Where?
It doesn't matter if they're coming together to do a drug deal,
But that's
and she's the transportation, and she's the source of packaging, and she's a source of protection. Those are things the jury.
Let's talk about the drug deal on March 5th. March
15th. This is the 15th.
Where in
They
the
came together on the 15th. I'm assuming she didn't know what was in the bag,
Yeah.
but she knew the bag was the device that they had used to store drugs. She had the drug baggies. She had some of her own drugs, and which could have been earmarked for somebody who had already ordered them. And she had the loaded gun under the seat. The question is, and she provided the transportation. So the question is that aiding and abetting distribution?
only if you can show that there was in fact a drug deal on March 15th, 2023, because that's indictment
It
specific.
was possession with intent to
On March 20th.
15.
Yeah, did they, and again, that, I just keep going back to that specific date in the indictment. If
Yeah.
they could have charged her with conspiracy on that date, they did. I mean, they charged her, they were going to distribute that on that date. And then when she picked him up, she had the intent to distribute whatever was in that. And I just don't see the evidence. They have a tremendous amount of evidence each and every, like count 2 on February 23rd, when they made the control buy to Matt Warren. They have a tremendous amount of evidence saying, no, this is what's happening. Here, they're just, as Your Honor mentioned, there's simply nothing on that day in this trove of text messages.
If they're together, you don't text message when you're
But
together.
They're in a personal relationship. So the government's
I
argument.
understand, but on that day, they're together. They're engaged in an activity. He's in the car, she's in the car, and they're going somewhere, and they've got drugs. And the question
have
is,
their
they're not going to text.
15-year-old son. And I question the government, the fact, who was with Miss Allen on February 23rd is pure speculation. I can tell you right now, if it was her son, the government would have put that on the record and said, look, this is what she does. She brings her sons to these because that's when we arrested her. Her son was in the back car. The drugs were here, ergo, it's a distribution case. We don't know. It's pure speculation. Who was in the car with her when she made that delivery on February 23rd, 2023. But again, even in the light viewed most favorable to the government, I believe those 3 counts, which added 25 years to her sentence. She got 240 months for both counts 3 and 4. They're concurrent, and she got an additional 60 months for count 5. And with that, I would ask that your court panel overturn those, and grant her relief for those.
Thank you, Mr.
Time.
Cooley.
Thank you.
Want to thank both counsel for their fine arguments, and Mr. Cooley, I want to specifically thank you for taking on this court-appointed appeal. Needless to say, it's often challenging work, and we obviously couldn't do what we do without lawyers who are willing to represent defendants on appeal. You've done that ably today, and we thank you.
My first time arguing.
Well, the first time was very well done. And Ms. Williams-Durham, the same for you. Thank you for representing the interests of the United States and doing so ably. We're going to take a brief recess while the courtroom gets rearranged for the final argument, and then we'll come back and hear the third argument. We'll come down and greet counsel and then take a recess.
Honorable Court will recess.
Our third and final case this morning, 24-4272, United States versus Crawford. Mr. Brignac, welcome back. Good to see you.
Thank you, Chief Judge Diaz. May it please the court, Eric Brignac for Jonathan Crawford. We start at Joint Appendix 46. This starts very briefly like a very normal, typical sentencing. Does the defendant wish to be heard on these objections? No, Your Honor. Okay. Does he withdraw them? Don't withdraw them. At that point, the point where we say we don't need to be heard on them, we filed a pre-sentencing motion saying we don't need to be heard, that's when he changes. Joint Appendix 46, he is angry that we persist in the objection. He uses the word persists 5 times in 3 lines. And then in direct response to being told that it was just a Fifth Amendment preservation objection, Joint Appendix 47, he calls it absolutely incredible.
He doesn't quite say that. What he says is, it's an admission that I don't want used in state court, which is, and it's with respect to that particular objection. The court overruled the objection after the exchanges, making some very negative comments that he persisted. But then when it came to sentencing, this was never raised again. And the sentencing was based on, the departure was based clearly on 5K2 and 5K6, 5K1, 5K2.6 and 5K2.1. The court says that's the reason I'm departing upward.
And Your Honor, so
That's at page, that's all at page 68 to 70.
It is, and he does go into the departures. I just want to be clear, though, that when you were saying we talk about the state admission, are you making the argument the government made that we did not invoke the Fifth Amendment, or?
Well, the question is whether it is number one, a Fifth Amendment invocation. It is an admission that and I'm not sure what the admission is, because he persisted in saying the testimony was unreliable. And so the question is, would he persist in saying it's unreliable, or would he say, I don't know whether it's unreliable? Is that admission of anything? It was an objection with respect to what, a 2-point level?
Two level, Your Honor. And you know what he says,
and it's with respect to the December comment made about that the woman had been threatened, and he said she was unreliable.
Yes, he did say that.
He persisted in that.
He persisted in that objection. He did not need to be heard. He agreed to an upward departure or variance to 39 months. And what he says exactly, Your Honor, because I think this is one of those cases that comes down to the fine grain. Quote, Joint Appendix 46, for no other reason, ... we did not want to have it be viewed as an admission by the state court. I think that invokes the Fifth Amendment. That we didn't want to have it.
That is not clear, but I understand your point. It's implied maybe, but.
And then I guess we get then to Your Honor, I think what is.
Before you get to that, Mr. Brignac, do you think that the district court could reasonably have been offended by the notion that a victim who had been abused in the way that she had been shot in the arm, and I get it, that I guess the defendant is entitled to stand on his rights. Why would it have been unreasonable for the district court to have taken offense at the notion that she was unreliable?
And I think, Your Honor, the district court, I think, could have, but one question is, what did the district court do? He didn't say, you're poor victim, you're calling her unreliable, you're calling her a liar, you shot her and you're calling her a liar. That would be one version of anger, which could have focused much more on the word that Your Honors and certainly everyone who mooted me picked up on, which was calling her unreliable. But that's not what he said. We have to look at what he said. And he focused on the fact that you're persisting in the objection. This started when he asked, we said, we don't need to be heard on the objection. Do you withdraw it? Which, by the way, in district court doesn't happen a lot. A lot of times when you say, I don't need to be heard on that objection, everyone understands what that means. The court says, okay, you don't need to be heard on it. I find the PSR reliable. It's overruled. Let's move on. but that's not what happened.
Well,
here.
his last lines were this objection is clearly inappropriate. That's I think the word he used when he
I
made the ruling,
think-
and then he moved on to other things.
He actually called it Joint Appendix 50 ridiculous and a waste of time. So again, this wasn't just, I don't see why you're making the objection. I mean, this drove him. So that, okay, and this gets right to your second question, Judge Niemeyer. You're saying, well, look, he got him 60 months for reasons he gave on the record. So even if we invoke the Fifth Amendment, and even if the Fifth Amendment, there's no valid reason, which I think is very strong, you can't punish for that. That's not what happened here. Again, all I can do is point to what the district court said, and it kept relying on things that the record just showed wasn't true. He made a specific point of seeing it as a negative factor that we had zero infractions in the Bureau of Prisons over 77 months. Again, I've been doing this for a while. Zero is pretty rare.
But
And we don't.
don't you
I'm
think
sorry.
it might be a little unfair to make an argument that to imply that he had zero infractions when the court explicitly explained what his criticism of that was? He said he was now on home detainment, and he was given basically a weekend pass or 50, whatever the hours was, pass. And during that pass, while he's in the custody of the Bureau of Prisons, he obtains a gun, goes over and rifles through his girlfriend's materials, looks and finds a little note that probably a call or something referring to a boyfriend, some jealousy, and then shoots her. And she's pregnant at the time. Now, he didn't know she's pregnant, but his girlfriend, he shoots her. The judge is just outraged by the fact that while he's in prison, he behaves, and as soon as the Bureau of Prisons retains custody of him and lets him go home for home detention, and then gives him a free pass, he gets a gun and shoots his girlfriend. That's what was offensive about it. And the court says, I can't give credit to good prison conduct when all he was doing was waiting out until he could get into society.
And again, most transcripts are dry. This one's not, Your Honor. The way he put it, he said we were not having infractions because we could not, quote, wait to get back on the crime train. That's Joint Appendix 56.
So Brignac, even if you're right about the fact that he may have been incorrect with respect to that, the way he characterized it, the district court, that's a sentencing argument that you waived, right? Because you pled guilty and it's a plea
right.
agreement. And
yes,
the only issue that we need to consider that hasn't been waived is the Fifth
is the
Amendment.
Fifth
issue.
Amendment. And I believe, Your Honor, the government says this.
I'm not sure you didn't waive that. The question is, our cases say that you waive constitutional arguments with some rare exceptions. And the only one we have articulated explicitly is race. If we sentence somebody based on race, a waiver, that'll overrule a waiver. And we have indicated that there are potentially others. But as a starting point, the waiver includes constitutional arguments, right?
And Your Honor, I'll take these in seniority order, so I'll answer your question first. Chief Judge,
Are you saying that I'm older than Judge Niemeyer?
I would never, Your Honor. I just look at who's in the middle. Your Honor, I would say, well, I guess your point is this a substantive reasonableness argument in sheep's clothing? And the reason it's not is we're making, and I want to get to Judge Niemeyer's point, we're making a Fifth Amendment argument. To win, I need to show not just that the judge was mad, but that the judge increased his punishment, at least in part, based on him raising his Fifth Amendment rights. And to do that, I need to show that the reasons he gave, at least some of those, actually a lot of those reasons, are disingenuous. I kind of need to pull the disingenuous reasons off the sentence and then leave the sort of core of it there, which has to be the Fifth Amendment. Judge Niemeyer, I think what your question's getting to, we have the Archie case and the Carter case, which talk about, do I need to show an exception to the appeal waiver that it's a firmly established constitutional right, or does it just have constitutional implications? The Archie case, which I think is the one the government relies on, that involved it said, and the language was very clear, a constitutional right is not outside the appeal waiver if it is, quote, firmly established, quote, at the time of sentencing. Archie actually involved a post-plea change in the law. So it's saying, look, what you agree to, you sign this waiver, you give up some rights, the government's giving concessions. What you agree to is at the time of your sentencing, your sentence doesn't violate the Constitution. That's not the case here. These Fifth Amendment rights have been very firmly established. It was hard to find some cases because most of the time, district judges, just like in a vindictive sentencing case, don't give a sentence and raise their hand and say, oh, by the way, I'm doing this because you're exercising a constitutional right. The only case I could find, and it's in our reply brief, it's the Safrestein case out of the Ninth Circuit, 1987. There, the district judge was just really, really mad at what he saw were drug traffickers coming in from Mexico and never being able to punish them for that. So he expressly said, I'm punishing you for not naming who your drug supplier is. And he said the Ninth Circuit can do with this as it will. So it was a rare situation where the judge violated the Fifth Amendment on the face of the record just to make a point.
Why doesn't Jeffers, our decision in the United States versus Jeffers, where we said that a sentencing court should not utilize a defendant's invocation of the Fifth Amendment as negative evidence to penalize them at sentencing?
Yeah, well, that could certainly there too. I think this right is firmly established. I think it also implicates the Constitution. I think the core of Judge Niemeyer's question is, did we waive the right to bring this claim? And I don't think any defendant can fairly waive his right to say, look, yeah, I'm giving this up and I'm going to be sentenced.
Why didn't he object at the time?
Two reasons, Your Honor. He invoked the right. I would say the point where we said we have the only reason we're doing this is to preserve. I think the district judge was aware he couldn't do that. This wasn't some subtle, complicated argument we were making. And I think in terms of timing, Your Honor, again, the judges, we've read a lot of transcripts. Judges can be very angry at the sentencing, and district judges are allowed to be angry. And what they can't do is increase punishment for invalid reasons, in this case, an unconstitutional reason. And when that happened, at that point, the sentence was announced. And there are multiple cases we cite in our briefs talking about the fact that we don't need to then make a post-sentencing objection. But even if Your Honors think we didn't object timely, it's still on plain error. And then, the error, it's plain. Again, this has been established, in this court and others for a very long time. It affected his substantial rights because if it didn't, we only win, I will acknowledge, if that 60-month sentence appears to have been motivated in part by a Fifth Amendment violation. So if that's true, it affects his substantial rights. And then I would say under the fourth prong.
Where's the burden of proof here? Is the burden of proof on you to show
The
that it
burden-
would be
so-
substantially affected?
I think it is certainly on plain error. On plain error, it is definitely on us. Otherwise, I do think it's still my burden to show, even if, as I say, I think we preserved it, and I think we didn't waive our right. I think the answer is the best analogy comes from North Carolina v. Pierce and the follow-up case, Powell v. Alabama. Well, anyway, the follow-up case is saying that, like, when you're making a vindictive sentencing claim, you have to show, I have to look at the record and say, look, this sentence was motivated in part, appears to be motivated in part by the defendant exercising his appellate rights. So I do think the burden is on me to say this 60-month sentence was motivated in part by his invocation of the Fifth Amendment rights. How do I show that? Two ways, how angry the judge was and how the judge told us it's that he persists in the objection. He persists.
Well, that was
Not that
early
he's-
on. So when he got to the sentencing part, where he actually ticked through the 3553A factors and entered his findings on the departure, you can't tell from the record, but it seemed like he was objectively going through the record and highlighting the reasons why he thought you're in contempt.
I always thought it would be me.
Yeah, go.
So anyway, so at that point, what's the evidence of vindictiveness when he's pulling, evidence
Yeah.
from the record to support his sentence?
And I would say two things. I think some level of upward variance was appropriate.
Well,
And
they conceded that.
They
right?
we conceded that, which, by the way, I have trial counsel here with me, and he can say, it's not easy to get a defendant to say, here's your guidelines, and by the way, we're going to go in and argue for something more than that because that's what you deserve. The government agreed to it. It's not anything the court was bound by, but that gives us a sense of maybe what that behavior, the behavior with the gun, with the girlfriend, the incident there was worth. And then I look more at what he said. So there were some valid reasons. He gave those reasons. We kind of came into sentencing saying, other than raising the Fifth Amendment to protect us in state court, we're okay with accepting punishment for that. It's what he said that was wrong. Joint Appendix 56, he called his criminal history shocking when it actually wasn't most people on an escape charge have a higher criminal history. He said, your dad was career Army. You didn't have an
Well,
unstable
hold it.
childhood. Yes, Your Honor?
That record started at age 17 and was
It's-
continuous up to his age 41. I
Yes.
mean, it was one crime after another.
You're right, Your Honor.
I don't know
His
how many
father-
there, but the court listed every single one of them. And he said that there was nothing redeeming in his criminal history.
Yeah.
He relied on three things for the departure. And his sentence is explicit, beginning at 68. He said, number one, this man possessed a gun when he was not entitled to possess a gun. That in and of itself would have been a 15-year violation. In other words, a felon possessing a gun, and the court observed that. Yet he wasn't charged because they didn't have the gun and they couldn't trace it to interstate commerce. That was the big thing. Second thing is he used the gun and injured somebody. And the third thing is his criminal record was consistently constant since age 17. And he listed every single one of those. And he said, therefore, so his 60 months is far less than the 15-year minimum he would have gotten had he had the felon in possession of a gun. And he was a felon and he was in possession of a gun. It's just that the government said they couldn't prove it because they didn't have the gun.
May I respond to those 3 points,
Yes.
Your Honor? Point one, Judge Niemeyer, I would actually say the fact that the district judge is, again, so angry, this all comes after we raise our preservation, that he's talking to the prosecution and saying, I want to put on your hat. Like, why aren't you making this guy an ACA guy? I can't believe you're not doing that. That's pretty, if I have to show that there's something more going on here, this isn't your mind run sentencing, those kind of comments I think actually cut in my favor. The second point, Your Honor, the fact that he had a gun and he shot somebody, yes, we're not denying that. That's why the 18 to 24 month sentence is inappropriate. And the third point, he started at
No, it's
7.
more- It's more than that. The court observed that, asked whether he had been charged for the possession of a gun, which would have been a 15-year violation. And the government pointed out that they never recovered the gun. And the ammunition wouldn't be sufficient to show that it was in interstate commerce. And that is the only reason, that technicality, because it's clear he had a gun and it's clear he was a felon. And that the court gave a lot of weight to that. That was the 5K2, right?
Yeah, and the state, I will also note, he had pending state charges. And finally, yes, he started his criminal history at 17. Joint Appendix 114, dropped out in the 9th grade following the death of his father, started using drugs 2 years after that, started his life of crime 3 years after that, all of which is to say, when the judge says, you had a stable childhood, so I'm going to increase your sentence based in part on that, when the record shows the exact opposite. I see I'm significantly over time, Your Honors, so.
All right, thank you,
See you
Mr.
on
Brickback.
rebuttal.
Ms. Englander?
Morning, may it please the court. My name is Kate Englander and I represent the United States. The defendant shot his pregnant girlfriend while he was in Bureau of Prisons custody and threatened to shoot up her residence if she cooperated with police. The defendant argues that the district court punished him for objecting to those facts at sentencing in violation of his Fifth Amendment right. But the record demonstrates that the defendant was punished for his conduct and his criminal history, not for making an objection. And I want to start with the three main arguments that the defense argues shows that the defendant was punished for this conduct, and I want to respond to each of those. First, they argue that the court's reaction was an indication, which was negative. The court's reaction was negative to the objection and the persisting in it.
Ms. Englander, I'm sorry to interrupt you, but before you get to that, do you concede that it's fairly established that a sentencing court can't punish someone for exercising his Fifth Amendment rights?
No, Your Honor, at least not as it's constructed in this case. So I think that there are it is firmly, there are certain constitutional rights, obviously, at sentencing, you have a Fifth Amendment right. But it's not absolute by the time of sentencing. The courts have recognized that there are exceptions. The right is more limited. The defendant is not insulated from all the hard choices that they would potentially have to make at sentencing. And I think what this court has recognized are certain very limited exceptions to appeal waivers based on alleged constitutional violations. I don't think that the issue raised by the defense here is one of those firmly established constitutional rights. And I'll give the court another example. The Carter case, which I think both parties talked about in their brief, this court recognized that it was not firmly established that the defendant's Fifth Amendment rights were violated by getting a harsher sentence for not identifying an accomplice. This court said that that was not a firmly established constitutional right. I think this court left open the question of whether it was a constitutionally impermissible factor. But I think in this case, the merits, I think, are more clear, frankly, than the waiver argument. But I do think that we're certainly not conceding that this wouldn't be encompassed by a defense appeal waiver. Looking to the merits.
That may be supported by the fact that he persisted in the substance of the unreliability of the testimony. Instead of saying that whatever I would say would incriminate me, it was basically persisting on unreliability testimony. And
I think that's
his choice would be for him to say, yes, I still persist in that, which he did formally do. Or his other statement was, well, I didn't have much knowledge to make that statement, which is not, would not be a clear Fifth Amendment problem.
That's right, Your Honor. And I think to give some context to the way the objection sort of evolved, and I think it explains some of the court's reaction. The defendant first files an objection to the PSR in which he says, Mr. Crawford asserts that the statement provided by CG to authorities is unreliable. The victim is unreliable. Then a few days before sentencing, the defendant filed something where they did say there are pending state charges and we won't want to be heard further, but they still asserted at that point in that filing, and this is at page 40 of the joint appendix, the defense maintains its objection to the veracity of the information provided to authorities by CG. And when the court picked up and started to address the objection, that is how it framed it. So at 47, the court says he contends that the information provided by CG, quote, all information regarding the events that occurred on November 20th are unreliable. So I think the court was responding to the content of that objection, not just to the fact of it. And I want to make just a few points about the court's reaction too. I think first, the defense concedes that the way the court reacted is not enough to prove a Fifth Amendment violation on its own. Second, I think it is important that some of the comments that the court made, is especially the he persists, that initial sort of reaction, actually came before the defense asserted, like, again, we don't want to be heard on this, there are pending state charges. So at that point, I think the court still believes, and I think still believed throughout the proceedings, that it was dealing with a factual objection to the PSR. And then a factual objection to the PSR, this court has said, has to be resolved by the district court. And I also think, looking at page 60 of the joint appendix, the court says, right, all right. And he shoots her. I get the pending charges, fine, but he shoots her. And I think all of that indicates, again, that what the court is reacting to here is the allegation that the victim is a liar. So I think that deals a bit with the court's reaction. The second thing I think the defense points to in arguing that the court was actually punishing the defendant for making the objection is the court's lengthy explanation in overruling the objection. This court has asked, frankly, district courts to explain why they're overruling objection. Just because the district court maybe it didn't have to, maybe it did. But it certainly wasn't error for the district court to explain why it believed that the objection should be overruled.
So if the district court based the sentence on 6 different factors and 5 of them were perfectly constitutional, but the 6th one was not, the 6th one, let's just say, was because he invoked his Fifth Amendment privilege, would that Would that be an unconstitutional sentence?
If you're saying that the sixth factor was just the fact of the objection, that the court was offended by the fact that the defendant was asserting his Fifth Amendment right, perhaps so, but not. I don't think it would be a violation if what the court was responding to was the content of the objection. In other words, that the defendant was calling the victim a liar. But again, there's no indication in this record that the court did either of those things. The indication in this record is that the court used the upward departures and the 3553A factors as the justification for its sentence. And in order to reverse here, this court would have to believe that essentially that the district court was being dishonest about its reasons for the sentence. And there's just no reason to believe that, and certainly not where we're on plain error, that any error in that regard certainly isn't plain from this record.
Do you think it matters in the way the district court described the defendant in arriving at its sentence? I mean, it was pretty colorful, pretty stern. One-man crime wave, a sociopath, no redeeming value. He's been lying in wait in the halfway house. I mean, there was utterly not one positive thing that the district court had to say about the defendant, and maybe there wasn't anything to say. But what about that sort of just really harsh tone? And is that even something that you can raise on appeal given the appeal waiver?
So no, it's not something the defendant can raise on appeal given the waiver. Now, I suppose there could be circumstances where if the district court's conduct was so out of line, this court could probably find a miscarriage of justice exception. I certainly don't think anything the district court here said would justify finding that. That the arguments in that regard, I think, really go to substantive reasonableness, which is something that the defense waived when it entered into the plea agreement, an argument that they can't make. Arguments about sort of the way that the district court explained its sentence don't go to, or don't indicate in this case that he was being punished for violating his Fifth Amendment rights, which is what this is what the defense would have to show here in order to show a violation.
Well, Mr. Brignac argues that, in fact, there were a couple of factual errors in the description of the court's analysis of the sentence. And I think he's arguing that, in fact, that the tone does matter because it shows an underlying malice or ill will toward the defendant, which he wants to trace back to the earlier language about persisting in the objection.
Right. So, and I think, again, I think this court would have to discount the district court's stated explanation in order to find that there was a Fifth Amendment violation. But just looking at, at their argument that the sentence wasn't justified by the 3553A factors or wasn't justified. I mean, they agreed that a 39-month sentence was appropriate. The court went up to 60 months. So 21 months over what they were asking for. But I think given the nature of the conduct here and the criminal history and the court's own explanation of that, which was internally consistent, that was an appropriate sentence. So, I mean, what the court said is, the only reason that this wasn't a murder was basically that the defendant got lucky. To meet in the court, said to the district court that justified a sentence at the very, very top. He said it was the rare case that justified a sentence of the statutory maximum. But this was such a case, and he explained why. And again, I think that the defendant might disagree with some of the court's explanation, and that was certainly something that if they hadn't been entered into a appeal waiver, they could have raised here. But that doesn't go to show that there was a Fifth Amendment violation, unless this court just totally believes that the district court was being dishonest about its reasoning, and I don't think there's any indication to that effect. And again, I would point to the fact that I do believe we're on plain error review here, and I'm happy to address why if the court's interested, but certainly any error is not plain here, where the district court is making a very thorough explanation for why it believes that its sentence is appropriate.
Well, it spent 3.5 pages explaining its ruling on the objection, and none of it related to any suggestion there was a Fifth Amendment violation. Basically, the court went into the facts in detail, hour by hour, what happened, what was said, who shot who, and so forth, and said his statement is clearly incredible.
That's right, and I think the court, the court obviously takes its obligations seriously when it's presented with a factual discrepancy that it has to resolve its sentencing. This court has told district courts you have to resolve those factual disputes. And it appears that's exactly what the district court did. And I also want to point to the fact that I think the defense in their brief makes a lot of the fact that the district court said, I overrule that, and then spent a very long time explaining why. You know, law students are taught that you state your conclusion up front and then you explain. I think the fact that the court initially said, I'm overruling it, and then provided the analysis is not an indication that the court was angry or that the court was sort of reacting to the objection itself as opposed to the content of the objection.
Would you address the plain error issue? I think from a practical perspective, it would have been pretty difficult for Crawford's attorney, who I understand is sitting here with us, to raise an objection after sentencing. Not only the issue raised of having not a lot of time, but essentially that you would have been need to stand up in front of the district court judge, tell the judge that he believed the judge had just violated the Constitution, and then have to, I assume, appear before that judge in the future in many other cases, potentially compromising the lawyer standing before that judge with other cases.
I don't disagree that that could be difficult, but that is what the law and the rule requires. And I will just point out the fact, page 77 of the joint appendix, which is the very end of the sentencing, the district court does ask defense counsel if he has, after pronouncing sentence, if there's anything additional. That would have been an opportunity if defense counsel really believed that his client's Fifth Amendment right against self-incrimination had just been violated. That would have been the time to raise it. And that's what the defense needed to do in order to preserve the objection and to have it on de novo as opposed to plain error review. Now, under either standard, the government prevails here because there was no error. The district court simply did not punish the defendant for making this objection. But I do think, you know, there are a few additional arguments that we make based on the fact that it's on plain error, and I think that is appropriate. I do want to respond briefly to the two cases that the defense cites for why they don't believe plain error is appropriate here. The first is Rogers. That's a very different case where the error is not clear until the written judgment is issued. Here, any error would have been clear at the time if the defense believed that there was such an error. That would have been clear during the sentencing. Nothing that happened after the sentencing would have made that more apparent. So that would be that one. And then also Hogan Hernandez, the defendant does preserve a challenge to a higher sentence where they argue for a lower sentence. You know, that again is a case where the district court is on notice based on what the defense has asked for, that they believe sentence higher than that is substantively reasonable. And so I think those cases are very different than what we have here. The defense did have an opportunity to object. They didn't do so, and that's why plain error review is appropriate. But again, under either standard, there was no error. But if we look to the plain error standard, again, we would just have to assume that the court's explanation here, in order for this court to reverse, that the court's explanation for its sentence was entirely pretextual, or mostly pretextual, and not, I think the court deserves the benefit of the doubt that its explanation was the real reason that it was doing, presenting the sentence that it did. And furthermore, the defendant's substantial rights weren't implicated by any error. So the court said that this sentence was the appropriate sentence for this defendant based on all the 3553A factors. And so, again,
I don't understand that argument, because it seems to me if we find that the error was plain, we have found that in fact the defendant was punished for exercising his Fifth Amendment rights. So how can we say that that wasn't a substantial injustice?
I think, Your Honor, still the fact that the court is saying this is the appropriate sentence.
We've rejected that. We have said that. I think your best argument is that there's no error here at all. But if we get to those prongs, I just don't see how you prevail.
Well, I think certainly the plainness prong does make a difference in this case, because again, first of all, I don't think that there are several things that are not plain here. It's not plain that the defendant invoked. It's not plain that the district court punished the defendant at all for any supposed Fifth Amendment invocation. You know, and it's not plain that the district court made that its explanation for the sentence was pretextual. So again, I want to turn back to the defendant's argument that the sentence was not justified by the 3553A factors. Again, the court went through all of this, but the defendant shot his pregnant girlfriend, at the first taste of freedom, he conditioned taking her to the hospital on her basically her statement that she wouldn't go to the police. He threatened to shoot up her residence if she cooperated. He then absconded for months and had to be tracked down by the marshals. He has a very extensive criminal record. I think the defense says basically he's only a criminal, has history category 5 out of 6. That's not shocking. I think the district court expressly disagreed with that. It went through all of his criminal history, pages 71 to 72 of the JA. But I think that it's also clear from the PSR, he had an extensive record, not all of which was scored, but which was basically continuous from the time that he was 22 up until the time that he is still in BOP custody and committing another crime. So based on all of that, I think the 5-year sentence was certainly not unreasonable and was not out of line with the court's own explanation. I see I have a little more time, but if there are no more questions from the court, I'll leave.
Thank you very much.
Thank
Mr. Brignac?
Thank you, Your Honors. I want to respond to some of your questions. I'll respond first. Ms. Englander said, that the Carter case helps them. In Carter, this court found there was no Fifth Amendment invocation, that nothing the defendant said put the district court on notice. So it just didn't reach the issue.
I know, but that hurt you because the court cited cases where you have to specifically invoke the Fifth Amendment or waive it. And I must say, an admission of fact that was referred to, he says, I don't want an admission for the state court, is not necessarily an invocation of the Fifth Amendment. It could also just be an evidentiary question that the pre-sentence report, he actually objected and said it's unreliable and stayed on that. And then the court spent 3.5 pages or whatever it is. It's quite a few pages going through why that objection of reliability was ill-founded. And none of that, the court didn't even hint at the fact that there was a Fifth Amendment issue at all. It didn't even recognize a Fifth Amendment issue. And I'm not sure, based on that one sentence, there is one. It's not clear to me, I must say.
Okay, and obviously, if we didn't invoke it, then there is obviously a.
No, I understand.
We did, and we did, Your Honor.
And I'm not telling you, we won't look at this closely, but I'm telling you, the record shows the court was concerned with the reliability statement and spent then 3.5 pages saying why that was an improper position.
The court was concerned that he persisted. Why are you doing this? We were doing it to protect ourselves from state court admission. To answer your question, Judge Berner, I think certainly if a judge relies on multiple valid factors and one or more invalid factors, which is what we say happened here, that's an improper sentence. I mean, I think there's a lot can justify a sentence, but if a court, relies on some improper fact, I don't think this court's ever hesitated to say if we think that affected the sentence, which is the question. Judge Diaz, I agree. I don't think we can ignore this transcript. Transcripts, again, are normally pretty dry. This one, I don't think we need to pretend that what happened here didn't happen here. I don't think we need to look at how incensed the district court was and not say, okay, there was something more going on here. This wasn't a typical sentencing. And also to get, again, maybe to the manifest injustice point about the appeal waiver, this was a case where a defendant tried to preserve a Fifth Amendment right as unobtrusively as possible, filing a motion before sentencing saying we don't need to be heard on it, mentioning we don't need to be heard on it.
And if
yes, of course.
Sort of raises, every time that argument is made, it raises the question of he made an objection, formal objection to the pre-sentence report, and says the statement that his girlfriend made that he was going to shoot up the house was unreliable. And then there's an objection. The objection is brought up in court, and the guy says he persists in it. to the judge's surprise because they had so much evidence there about the circumstances, the details. And the lawyer says, I don't want to make an admission for state court. What is the admission that he's referring to?
The admission, Your Honor, is the admission that he shot his girlfriend, that he threatened to shoot up her place, for which he was facing charges for which he had been indicted in state court.
I
This was
understand,
not
but he made the
hypothetical.
objection. And now the
Yes.
question is, the judge wants to hear what's his position, why? It's not a question of forcing him to say it. He already said it. It's unreliable. And the judge says, why is it unreliable? And he said, do you want to withdraw it? And he said, no, I want to preserve it. And he wants to preserve it so as not to make an admission. And that's the part I can't figure out. What's he preserving his testimony that it was unreliable? He wants to preserve that. And that's all he said for state court. Now,
He said, Your Honor, out of an abundance of caution.
understand, yeah.
And so I would say, this wasn't hypothetical, one day someone somewhere may prosecute
no,
me.
I want to understand what is the admission that he's
He-
trying to protect against.
What he did not want, out of an abundance of caution in consultation with counsel, was for the state prosecutor to be able to, in state court, say, in federal court at sentencing, he was accused of doing this and he did not object to it there. And that's all. We just wanted to protect ourselves in state court, as the Fifth Amendment gave us every right to do. I, again, went over time I
Yeah, but-
apologize.
Not objecting to something is a Fifth Amendment violation?
We weren't sure. We certainly didn't want to have that question answered in the
Yeah,
negative by the state.
And
court.
that's probably good lawyering. But the real question then is, where you're now elevating that good lawyering into a Fifth Amendment objection, and I haven't understood it since I read the brief.
Well,
I mean,
and that's, Judge Dever could have certainly said, you're raising this so it's not an admission, but you're not admitting anything. You're just failing to object. We could have.
no, he's not failing to object. He did
I'm
object.
sorry. I'm
That's the
sorry.
point
I
that you-
misspoke.
Yeah, but
You're-
that's
you're
what the point,
objecting-
just a minute. That's the
Sorry,
point
sir.
that the judge made, that he made an objection and the judge asked him about it. And he says, I don't want to say anything further. And the judge says, are you withdrawing it? And he says, no, I'm persisting on it. And then he says, I do not want to make an admission for state court. And I never understood what the admission was, because the judge was just asking him to respond to his objection.
And all I can say is the admission, I can tell you what's true. Maybe we were wrong by thinking it was this, the
Well,
admission.
you don't need to give us your,
No, I'm sorry, the admission was the factual underpinnings of the interaction with his girlfriend. And I agree with Judge Diaz. I just want to say that everything in this case, if this court agrees with us, I think everything sort of falls away. Plain error, appeal waiver, assignment to a different judge. If Judge Niemeyer, I think if the court, takes the position that there was no error, then
no,
there was no error.
No, I was just curious where the admission was, because
And
we
it-
have the one statement she made,
Yes.
which was he said he was going to shoot up the house. And he reported that, and that was the basis for an objection of obstruction of justice. And you objected, or your client objected to the obstruction of justice on the ground that her statement was unreliable. So the judge now asks you, what is the basis for that? And you don't say anything further. And you don't want to say any further because you want to make an admission, but I don't understand the admission. That's the point.
And again, it obviously could have been phrased differently, but I do think the way we phrased it was enough to put the court and put the government, everyone on notice that both at Joint Appendix 40 in our motion and at Joint Appendix 46, 47, that what we were doing was preserving it. And by the way, if you look, the district court kept cutting him off. So, I'm not exactly sure what else Mr. Wiclair would have said, but we were also somewhat with both hands behind our back once the persistering started. So again, over time, I very much appreciate, we would ask this court to vacate and remand to a different judge with instructions not to use his objection against him.
Thank you very much. Thank you, Mr. Brignac. I want to thank both lawyers for their fine arguments here. Still morning, 5 minutes left. And Mr. Wiclair, thank you for taking the court appointment in the district court. We appreciate your service in this criminal case. And as always, appreciate the fine advocacy of the government lawyers here. We'll come down and greet you, then head back and conference the cases, And then we'll come back and meet with the students after we're done conferencing the cases.
Honorable court stands adjourned. God save the United States and its honorable court.